My name is Jeff Anderson. Also present with me is Mike Finnegan, and present with us by telephone is Professor Marcy Hamilton. We are three of the lawyers who represent this courageous survivor who 9 years ago took on the Vatican and now has been given a green light to move forward in his case and require them, that is the Vatican, to answer questions and to answer perhaps in a courtroom and reckon for their role in a worldwide cover-up of sexual abuse by clerics. Perhaps Professor Hamilton can begin by explaining to us what the real significance of this decision by this trial court after 9 years is. Professor Hamilton.
Hi, Jeff. This is really a remarkable opinion for several reasons, but the most important element of this decision is that it's the first time that the Holy See, the Vatican, has been required by any American court to respond to discovery for a child sex abuse victim. And every sovereign, just like the sovereign status of the Holy See, has the ability to claim immunity. And the Holy See in all of its cases claims it with a lot of gusto and has been arguing for 9 years that we don't even have jurisdiction and that they don't have any responsibility whatsoever. What this decision says, we have been successful in persuading the court that the Vatican may well be an employer for Andrew Ronan, the priest who committed the abuse in this case, and that this survivor can go forward and require a lot of documentation as to how they operate, how they control priests, what they tell them to do. And the most interesting part of the opinion to me is that the court has agreed with us that it is possible for any priest to have more than one employer at a time. So even though the Holy See obviously is not on the ground every minute with a priest, the Holy See has reserved its right to transfer and remove its priests for child sex abuse. It's reserved all powers with respect to sex abusing priests. And that is something that is not part of any opinion before, but it's going to open the door to lots of discovery that they're going to have to produce according to the court within 60 days.
And what we have learned in the last 27 years and having represented not only this survivor but thousands across the country and even across the globe is that all the evidentiary trails and the cover-up of clerical sexual abuse lead to one location, and that is to the top, and they all lead to Rome. And in this case, the priest was moved from Ireland to Chicago to Portland with a history. But every road from every continent, when it comes to the worldwide movement of these priests, has demonstrated for 27 years that all decisions, all practices, all protocols requiring secrecy and cover-up are made at one place and in one office, and that is the office of the Vatican and by the papacy. And the decision of this court to allow this survivor and this case to compel the Pope and its representatives to answer these questions and in this courtroom is not only monumental, but it's historic in its proportions, in our ability and his ability to protect children worldwide. Mike Finnegan has done a lot of the hard, heavy lifting here. Mike, what do you attribute to the the significance of this today?
Significance, as both Jeff and Marcy have pointed out, that this is the first time that any clergy sex abuse survivor has been able to force the Vatican to turn over their secret documents and answer questions, and they're required to do that within 60 days. I just want to reiterate how much respect and admiration we have for John V. Doe. He stood up to the Vatican officials for the last 9 years and has persevered through all the delay tactics that the Vatican has employed trying to take this case up to the U.S. Supreme Court. And he's persevered that whole time, and we applaud him and his courage. And what this decision really means is what the survivors have been asking the Vatican to do for decades, and that's to come clean. Come clean and release the documents that they have on the sex offenders, come clean and release information about how they've handled clergy sex abuse. And we're honored to be here today with this courageous survivor.
And I would add that this decision comes only because of the courage of this survivor and others like him to break the silence and to take action. But it also signals a trend that I think is really important, and it's a global trend, a worldwide trend, and that is that secular authorities, as in this case of this court, as in the case of Belgium where they arrested the bishops and seized the records, as in the case of the Philadelphia grand jury where they made findings, it signals a real trend that is hopeful for child protection, that shows that courts and secular authorities across the globe and now in the U.S. are recognizing this is a global problem, that the evidence and the trail of the evidence leads essentially to one place, and control is exercised by the Vatican, and this is a global effort to really exert pressure on them to do a better job of protecting children and to coming clean, becoming transparent, and this is a day of reckoning and a hopeful sign and real progress. Marcy, anything to add?
No, only that they cannot appeal this decision, and so 60 days is 60 days, and they're going to have to produce the document or else. And so this is one of those moments when all of these years of litigating by the Holy See against victims is coming to a head, and finally they're going to have to do more than just put up defenses. They're actually going to have to put up information, and that is a huge development around the world for victims.
And we are posting on our website at andersonadvocates.com not only the significance of this decision and commentary, but specifically the questions that the court is requiring the Vatican to answer, specifically the documents the Vatican is required to produce, and most notably, that is all the policies, all the practices, and all the declarations the papacy has made since 1950 pertaining to clerical sexual abuse. And they are required to answer those questions and produce those documents in 60 days. And at the end of that time, we have an opportunity to then ask for and perhaps even require sworn testimony under oath. And for this, we are not only excited, but we are grateful to the courageous survivors with whom we stand in this effort and on this case, and to my colleagues who stand with each and every survivor. Questions?
I wanted to ask whether the documents are going to be made public or whether you will have those documents. What documents will be totally open, and are there other things that are just going to be closed as the court proceeding takes place?
The answer is the documents and all proceedings in this case are open to the public, and everything that is produced in this case is required to be made public, and it will be made available to us, and it's simultaneously filed and required to be filed with the court, and at all times public. And one of the imperatives that we answer in this case and in this effort is the public imperative. Secrecy and privacy permits sexual abuse to occur. The dissemination of this information publicly and broadly permits children to be protected. And so the public imperative is answered here by keeping this proceeding open and using the crucible of the courtroom and public awareness to better protect kids. It's an important question. It's an important piece of this case.
We have a question from the Associated Press. They were told by the Vatican's attorney, Mr. Lena, that the 60-day deadline is not necessarily right. The reporter said, I read the order and it seems in there like it's a 60-day deadline. Could you comment on Mr. Lena's comment?
Well, the attorney for the Holy See, Jeffrey Lena, has commented that there's not, in fact, a 60-day deadline. We've read the court's order very carefully. The court has deliberated upon this matter not only for months but years, has deliberated upon thousands of pages of documents in opposition to this, and our reading of it seems to be pretty clear that they are compelled to produce these things within the time limit specified. Finnegan, do you have the order there? Is there any lack of clarity?
No, there's no lack of clarity. The order says in multiple places that the Holy See shall respond to the discovery, including the secret documents, including the questions that we asked of the Holy See within 60 days. It says it numerous times in the order here, and any arguments to the contrary are clearly answered in this document.
It should also be noted that this case started 9 years ago. The Holy See appealed the original decision of the trial court to allow us to go ahead to the Ninth Circuit Court of Appeals, all the way to the U.S. Supreme Court, and it's now been sent back down to this trial court that has been very prudent, that has been very careful, that has been very cautious, and also very clear when it states it's now time for reckoning, it's now time for production, and Holy See, you got 60 days to start to answer the questions put to you.
Jeff, this is Marcy. Not only does the court say there's only 60 days, but the court then says that at the end of that period, once we've had 30 days to assess what they finally give us, we can ask for a federal rule deposition if we can show that it's crucial. So not only has the court given them only 60 days, they've also given us an opening to argue for even more discovery, and then limited the plaintiff's response to that to 14 days. And so there's really no wiggle room in any of the timing in any part of the order.
And it is clear that the Holy See has not only wiggled for a long time, they have denied, minimized, blamed, and run and operated above the law for a long time. And this is a real, authentic opportunity to hold them accountable under the law, as instead of allowing them to operate above the law.